May 16, 2008. A Thursday morning in Jalvayu Vihar, Sector 25, Noida. A quiet, orderly residential colony of professionals, the kind of address that India's decade of growth had made possible for doctors, engineers, and corporate managers. The colony had wide lanes, guard posts at the gate, and the particular stillness of a place where nothing dramatic had ever happened. At flat number L32, Dr. Rajesh Talwar, a dental surgeon with a practice in South Delhi, had risen early and was preparing for his day. His wife Nupur was also awake. Their daughter Aarushi, 14 years old, a student at Delhi Public School Noida, cheerful and academically bright by every account, was, they believed, still asleep behind her bedroom door. The family's domestic help, 45-year-old Hemraj Banjade, a Nepali national who had worked for the family for several years, had also not yet appeared. It was an ordinary Thursday morning. Until Rajesh Talwar knocked on his daughter's bedroom door and found no answer. Until he opened it. And in that moment, everything ordinary about that morning and about that family's life ended. Aarushi Talwar was dead in her bed. The injuries that investigators would later document were specific and disturbing. Blunt force trauma to the head, precise and severe, followed by a deep incision across her throat. The wound was neat, the kind of cut that spoke of a specific implement used with deliberate force. Someone had drawn a sheet partially over her body after she died. The crime scene had been managed in some way after the killing. The police were called. A first information report was registered at Sector 20 Police Station, Noida, under Section 154 of the Code of Criminal Procedure, the mandatory document that sets the entire machinery of Indian criminal law in motion. The FIR charged the offence as murder under Section 302 of the Indian Penal Code, the provision that prescribes death or life imprisonment for the deliberate taking of a human life. It recorded one victim, Aarushi, because Hemraj was missing. And in the first confused hours of that Thursday morning, the working theory of the Uttar Pradesh police was devastatingly simple. The domestic help had murdered the teenage girl and run. That theory had collapsed completely within 48 hours. On May 17th, the door to the building's rooftop terrace was found locked from the outside with a padlock. A locksmith was summoned. The door was opened, and there on the terrace, partially concealed under a cooler canopy, lay the body of Hemraj Banjade, dead for approximately the same period as Aarushi. The injuries were strikingly similar: blunt force trauma to the head and the same precise incision across the throat. The man who had been named as the prime suspect, whose photograph was already circulating in the media as a fugitive, was himself a victim. Suddenly, this was a double murder. And suddenly the question that had seemed simple became something far more complex. Who had been in that flat on the night of May 15th into May 16th? Who had killed two people with precision and apparent calm? Who had covered one body and concealed the other on a rooftop? And who had then disappeared without any evidence of forced entry, without being seen by any neighbor, without leaving a clearly traceable physical trail into the quiet lanes of Jalvayu Vihar? The early investigation conducted by the Uttar Pradesh police was, by any honest professional assessment, a catastrophe. Section 174 of the Code of Criminal Procedure mandates that when a person is found dead in suspicious circumstances, the investigating officer must personally proceed to the spot, ensure the body is not moved before examination, and ensure that the scene is preserved for forensic examination on undisturbed evidence. These requirements were not met. In the hours after Aarushi's body was discovered, the flat was accessed by multiple police officers from different jurisdictions, by neighbors, and by media persons who had learned of the discovery within hours. Key surfaces were touched before they could be swabbed. Items were moved before they could be photographed in position. The terrace where Hemraj's body lay had been open to the elements and foot traffic for more than 24 hours before discovery. The forensic window, already narrow since the crimes had occurred 8 to 12 hours before discovery, had been shattered by carelessness before any systematic forensic examination could begin. This was not a minor procedural failure. It was a permanent, irreversible wound to the investigation, one that would eventually prove fatal to the prosecution's case. The UP police then compounded their investigative failure with a series of public statements that violated one of the most fundamental principles of Indian criminal law. Within days of Aarushi's murder, senior officers appeared before television cameras and made specific, detailed, and entirely unevidenced claims about the dead girl's character, about alleged relationships, and about the probable guilt of Rajesh Talwar. These claims had not been established by any evidence tested in any court. They had not been scrutinized by any magistrate. In legal terms, they were nothing. Speculation, dressed up as investigation, and delivered directly into the homes of millions of Indian viewers. This was a profound violation of the presumption of innocence guaranteed under Article 21 of the Constitution of India, which the Supreme Court has repeatedly affirmed encompasses not merely a formal trial stage protection, but a broader entitlement to be treated as innocent until guilt is established through a fair and lawful process. In the court of public opinion, Rajesh Talwar had been convicted before a single sworn witness had been examined. That conviction, once formed in the public mind, proved almost impossible to dislodge. The Central Bureau of Investigation took over in May 2008 under the Delhi Special Police Establishment Act of 1946, which gives it jurisdiction over cases of national importance or where state police have demonstrated investigative incapacity. By the time the CBI arrived, the crime scene had been compromised beyond recovery and the media trial had run for weeks. But the first CBI team's conclusion was startling. Rajesh Talwar was probably not the killer at all. The first CBI investigation identified 3 individuals, Krishna, Rajkumar and Vijay Mandal, all domestic workers employed in the same housing complex, as the more probable perpetrators. These men had been present in the building on the night of the murders, had been drinking, and had means and potential motive. In December 2010, the CBI filed a closure report under Section 173(2) of the Code of Criminal Procedure, formally informing the magistrate that investigation had concluded and insufficient evidence existed to prosecute any named individual. The case should have ended there, but the magistrate at Ghaziabad refused to accept the closure report. Under Section 190 of the Code of Criminal Procedure, a magistrate has the authority to examine a closure report and direct further investigation if not satisfied with the conclusions. It is an important check within the Indian criminal justice system designed to prevent investigating agencies from prematurely closing cases. The magistrate exercised that power. A second CBI investigation was ordered. And this second investigation reached an entirely different conclusion. It decided that Rajesh Talwar and Nupur Talwar, the parents, were the most probable perpetrators. In November 2012, the CBI filed a charge sheet under Section 173, naming both parents as accused under Section 302 of the IPC for double murder, read with Section 34, which establishes that when a criminal act is done by several persons in furtherance of a common intention, each is as liable as if the act had been committed by them alone. The same agency that had formally cleared the parents 2 years earlier now formally accused them. 2 contradictory conclusions, the same evidence. India's attention returned to the case with full force. The trial before the additional sessions judge at Ghaziabad lasted over a year. The prosecution's entire case rested on circumstantial evidence. No eyewitness, no confessional statement, no weapon definitively connected to either parent. Under Section 3 of the Indian Evidence Act 1872, circumstantial evidence is admissible. but the Supreme Court, in the landmark judgment of Sharad Birdhichand Sarda versus State of Maharashtra in 1984, established the precise and demanding standard that must be met before a person can be convicted on purely circumstantial evidence. The 5 conditions of the Sharad Sarda test are these. First, all the circumstances from which the conclusion of guilt is drawn must be fully established. Second, all those circumstances must be consistent only with the hypothesis of the guilt of the accused. Third, the circumstances must be conclusive in nature. Fourth, they must exclude every hypothesis except the one sought to be proved. And fifth, the chain of evidence must be so complete that it leaves no reasonable ground for a conclusion consistent with innocence. All 5 conditions must be satisfied simultaneously, not 4, not approximately, all 5. This standard exists because conviction without direct proof is the most dangerous form of conviction, the one most vulnerable to the substitution of inference for evidence, of probability for certainty, of institutional belief for legal proof. In November 2013, the Additional Sessions Judge convicted both Rajesh Talwar and Nupur Talwar of double murder. The judge held that the circumstances, the locked terrace door, the cleaned crime scene, the CFSL forensic findings, and the behavior of the Talwars in the aftermath together satisfied the Sharad Sarda standard. Both were sentenced to life imprisonment under Section 302 of the IPC. Inside Dasna jail in Ghaziabad, a couple who had already lost their child now faced the additional catastrophe of being legally labeled as the people who killed her. Supporters were outraged, pointing to the contaminated crime scene and the 2 contradictory CBI investigations. Critics felt vindication. The nation was sharply divided, and the legal process was not finished. Tell us in the comments where you are listening to this story from. If this story made you think differently about what forensic evidence and the presumption of innocence truly mean, please like, subscribe, and share this channel. Every subscriber tells us to keep bringing stories like this. Now, back to the story. Writing hand, a note from our team. We have researched this case extensively to bring you accurate facts, dates, and legal details. However, these cases span years of complex proceedings and some details may be imperfect. If you spot anything that needs correction, please leave it in the comments. Your input helps us serve every listener better. The Talwars appealed to the Allahabad High Court. Under Section 374(2) of the Code of Criminal Procedure, a person convicted of an offence punishable with death or life imprisonment has the right to appeal to the High Court. The High Court's appellate review is a full independent examination of the evidence. The High Court is not bound by what the trial court found. On October 12, 2017, the High Court acquitted both Rajesh Talwar and Nupur Talwar of all charges. The acquittal judgment, running to hundreds of pages, held systematically that the prosecution had failed to satisfy the Sharad Sarda test at every one of its 5 conditions. The circumstantial chain was broken at multiple points. Multiple alternative hypotheses had never been properly excluded. The forensic evidence, built on samples collected after an irreparably compromised crime scene, could not bear the evidentiary weight the prosecution had placed upon it. Under Section 45 of the Indian Evidence Act, a forensic expert's opinion is admissible but not conclusive. And when the material examined has been contaminated, the conclusions drawn from it are only as reliable as the material itself. The court found the foundation too compromised to sustain a conviction. Nupur and Rajesh Talwar walked out of Dasna jail on October 12, 2017, having served nearly 4 years of a life sentence. The CBI filed a special leave petition under Article 136 of the Constitution before the Supreme Court seeking to challenge the acquittal. That SLP remains pending. No one has ever been convicted of either murder. The 3 individuals identified by the first CBI team were discharged for want of sufficient evidence at an early stage. They never faced trial. 2 people, a 14-year-old girl and a 45-year-old man who had crossed a national border to earn a living were killed on a May night in 2008. And the Indian criminal justice system, across 9 years of investigation and litigation and two contradictory conclusions from the same investigating agency, was unable to establish beyond reasonable doubt who committed those murders. That fact, the bare, terrible fact of it, is the hardest thing in this entire story. The role of the media deserves its own careful examination because it illustrates a tension at the heart of a democratic legal system that India has not yet fully resolved. Article 19(1)(a) of the Constitution guarantees freedom of speech and expression. Article 21 guarantees the right to a fair trial. In a high-profile criminal case where television channels broadcast detailed theories about guilt in real time before any court has examined a single piece of evidence, these two rights come into direct and damaging conflict. Senior UP police officers stood before cameras and publicly characterized the character and probable guilt of a man who had not been charged, whose accusers had not been cross-examined, and whose defense had no opportunity to respond. Witnesses, investigators, and judges operate in the same society that reads newspapers and watches television. The damage that violation did to the fairness of the proceedings that followed is impossible to quantify, but it is real, and it persists. Even after the Allahabad High Court acquitted the Talwars, public opinion remained divided, the media trial having left marks that no judicial verdict could fully erase. The impact of the Aarushi Talwar case on India's forensic investigation culture has been significant. The National Forensic Sciences University, established in 2020 in Gandhinagar, lists this case among its foundational criminal investigation studies. The Allahabad High Court's acquittal judgment is cited in criminal law curricula across India as one of the most comprehensive examinations of the Sharad Sarda test ever produced by an Indian appellate court. Law enforcement training programs across multiple states have incorporated it as a study in the procedural requirements of Section 174 of the CrPC and the permanent consequences of failing to meet them. These are not consolations for what happened to Aarushi and Hemraj. They are evidence that the system, in its slow and imperfect way, has tried to prevent the next such failure. What does the Aarushi Talwar case teach us? First, crime scene preservation is not a bureaucratic formality. Section 174 of the CrPC exists because the quality of a criminal investigation is determined to an enormous extent in its first hours. Evidence is perishable, contamination is irreversible. The forensic scientists who examined the Talwar flat were working with evidence already handled by unknown numbers of people for unknown purposes. The conclusions they could draw were correspondingly limited. The first responders to a serious crime scene are the custodians of the possibility of justice. When they fail that custodianship, the damage cannot be repaired by any amount of sophisticated analysis later. Second, the presumption of innocence under Article 21 is not merely a trial stage protection. It is a right that exists outside the courtroom, in every press conference, in every television broadcast, in every public statement by every official who holds power over the investigation. Third, when two teams from the same agency reach opposite conclusions from the same evidence, this is not a demonstration that the evidence was ambiguous. It is a demonstration that one or both investigations were conducted under conditions that compromised their analytical independence. And fourth, proof beyond reasonable doubt is the highest standard in Indian law for a reason. The consequences of criminal conviction are irrevocable. The law demands certainty, not probability, not the most likely explanation, but the only reasonable explanation. The Allahabad High Court found that standard was not met. It did what the law required. Whether that produced justice for Aarushi Talwar and Hemraj Banjade is a question that the law, by its own design, cannot answer. The law is not designed to find the truth in every case. It is designed to ensure that the state never takes away a person's liberty without meeting the highest possible standard of proof. That standard is its most important protection, even when it leaves us, as this case leaves us, with nothing but silence where an answer should be. To fully appreciate why the Aarushi Talwar case became what it became, you need to understand the specific mechanics of how an investigation can be permanently destroyed in its earliest hours. Most murder investigations, even complex ones, resolve within a defined forensic window. The evidence that matters most, biological trace material, fingerprints, tool marks, blood spatter patterns, the precise, undisturbed arrangement of a crime scene, exists in its most complete and reliable form in the hours immediately after a crime. Every hour that passes without proper preservation narrows that window. Every person who enters the scene untrained introduces new material that can contaminate existing samples. Every item that is moved before being photographed and logged loses its evidentiary value. The Talwar flat, in the hours after Aarushi's body was discovered, was treated not as the scene of a crime requiring forensic preservation, but as a location to be visited and examined informally. By the time any systematic forensic protocol was applied, the window had long since closed. This is not a criticism of the specific officers who attended the scene. It is a criticism of a system that had not adequately trained its first responders in the forensic consequences of their early actions. A system that paid for that inadequacy, in this case with the permanent inability to establish what had actually happened. The impact of the Aarushi Talwar case on India's forensic investigation culture has been, in the long run, significant. The National Forensic Sciences University, established in 2020 in Gandhinagar, lists this case among its foundational criminal investigation studies. Law enforcement training programs across multiple states have incorporated the case as a study in the procedural requirements of Section 174 of the CrPC and the permanent consequences of failing to meet them. The Allahabad High Court's acquittal judgment is cited in criminal law curricula across India as one of the most comprehensive examinations of the Sharad Sarda test ever produced by an Indian appellate court. These are not consolations for what happened to Aarushi Talwar and Hemraj Banjade. They are evidence that the system, in its slow and imperfect way, has tried to prevent the next such failure. There is a dimension of this case that has received insufficient attention: the experience of Hemraj Banjade's family. Hemraj was 45 years old, a Nepali national who had come to India to work and had been employed by the Talwar family for several years, by all accounts reliably and loyally. He had a family in Nepal who waited for news and received first the information that he was dead, and then the experience of watching an investigation in which he was initially accused of the murder and then gradually forgotten. Once the focus shifted to the Talwars, Hemraj became a peripheral figure in the legal drama. The legal proceedings were conducted in the name of justice for both victims. But the public conversation was concentrated almost entirely on the Talwar family. Hemraj's family, separated by distance, language and circumstance, had almost no presence in the long legal story that followed his death. This is an observation about how the criminal justice system and the media ecosystem distribute attention in proportion to social visibility. Hemraj Banjade was less visible. His death was no less complete. His family's grief was no less real. And the justice system's failure to identify his killer is no less a failure for being rarely discussed in those terms. India's criminal justice system carries the gravest of powers. The standard of proof it applies, proof beyond reasonable doubt, is the highest standard of evidence the law knows, precisely because the consequences of error are irreversible. The Aarushi Talwar case illuminated with unusual and painful clarity what happens when the institutions that feed evidence into this system fail in their fundamental obligations. The police failed to preserve the crime scene. The investigating agency sent two different teams to the same evidence and got two different answers. The media told the public who was guilty before the law had even begun its work. And the court, receiving evidence that had been compromised at its source, could not honestly satisfy the standard required for conviction. The acquittal that resulted is the legal system doing the only thing it can do when the evidentiary foundation has been destroyed, refusing to convict without proof. The real lesson of this case is not about the Talwars. It is about every institution that plays a role in the chain between a crime and its legal resolution. When any link in that chain breaks, the truth may still be known by those who were there, but the law cannot reach it. The Aarushi Talwar case also generated a sustained national conversation about the rights of accused persons in a media-saturated environment. A conversation that India's legal system had not previously been equipped to have at this scale. The Supreme Court of India has, in various judgments including Sahara India Real Estate Corporation versus SEBI, acknowledged the tension between the freedom of the press under Article 19(1)(a and the right to a fair trial under Article 21 of the Constitution. The court has noted that sufficiently prejudicial media coverage can, in principle, affect the fairness of a trial. The Aarushi case never produced a specific legal finding that the trial was vitiated by media coverage. But it produced something arguably more important: a generation of Indian legal professionals, journalists, and citizens who understood, from having watched this case unfold in real time, that the right to be presumed innocent cannot be an effective protection only inside a courtroom while being routinely destroyed outside it. That understanding is not codified in any statute. It cannot be measured in any court order. But it is real and has shaped the standards to which Indian media is held and holds itself in the coverage of criminal cases ever since. The three individuals identified by the first CBI team, Krishna, Rajkumar, and Vijay Mandal, were discharged for want of sufficient evidence at an early stage of the proceedings and never faced trial. Their names appear in the legal record, in the first CBI investigation report, in the closure report that the magistrate refused to accept. But they never sat in a dock. They never faced cross-examination. They were never subjected to the scrutiny of a formal trial process. Whether they were the actual killers, whether the first CBI team's theory was correct, whether the truth of what happened in flat L32 on the night of May 15, 2008 matches the conclusion of that first investigation or some entirely different account, none of this has ever been legally established. The case remains, in the technical language of the law, unresolved. What this means in human terms for Aarushi Talwar's family, for Hemraj Banjade's family, for every person who followed this case hoping for a resolution that the law could not provide, is the heaviest and most honest answer that this story can offer. Sometimes, when the institutions that are supposed to find truth fail early and comprehensively, the truth is not recovered. And the law, having been given irreparably compromised evidence, can do nothing more just than refuse to convict. Aarushi Talwar would have been 31 years old in 2024. She was, by every account of those who knew her, a bright and cheerful girl who loved her parents, worked hard at school, and had the ordinary dreams of an ordinary Indian teenager. She deserved to grow up. She deserved to have her murder solved. She deserved to have the institutions that exist in her country's name perform their functions with the rigor and integrity that the law both requires and promises. She received none of these things. Hemraj Banjade deserved to go home to his family in Nepal, to the wife and children he had crossed a border to support. He too received none of these things. The Aarushi Talwar case is ultimately a story about failure. not the dramatic failure of a single corrupt individual, but the quieter, more systemic failure of multiple institutions, each inadequate in its own way, collectively unable to deliver justice for two people who had every right to expect it. Understanding that failure honestly and working to prevent its recurrence is the only meaning that can be made of a story that otherwise offers very little comfort. If this story moved you, if it reminded you that justice requires not just the will to convict but the rigor to prove, please share it with someone who needs to hear it today. And if you know of a case that deserves to be told, write to us. Every unanswered question has a story worth telling. This is HeartLine Justice, where the law meets the human heart.